shall be heard. God bless America, the great state of Ohio, and this honorable court. You may be seated.
Good morning. Today's date is July 25th, 2025. It's the morning docket of the Lawrence County Municipal Court. I'm acting Judge Brian Cremines. First group of cases we're going to call are review hearings. When you hear your name called, come down to the table on your right, my left, and we will go through your case. We'll call first case.
All right. Jeremy Butcher.
Review hearings need to be recorded.
Casey Jackson. James Eastman. Kimberly Jones. Michael Jones. Mark Wells. James Fortney. Benjamin Hawk. And Carolyn Rayburn.
Jeremy Butcher.
Yes, sir.
It's the state of Ohio versus Jeremy Butcher, CRA 1943, CRA 19779. Set for review. Butcher's present. All right. Butcher, looks like you've completed your community service and you're down to $400 left on the case. I haven't seen any new community service since last hearing. You can work off some of your fines based upon if you wanted to work some extra community service. Are you working currently?
Yes, sir.
All right. You work tomorrow?
Sometimes on Saturdays, but I don't think I am this week.
Well, we need people to do community service here. Since you've completed your community service, I won't order you to do it, but if you wanted to shave off some money off your fine that you don't otherwise have to pay, and we're talking, these are 2019 cases, so they're almost 6 years old. I would think that you probably wouldn't want to come back to court every.
Most stuff's restitution, ain't it?
I believe he is paying restitution.
Okay. Okay. All right, well, I'll set you back for another review.
If he can check with us in probation, we can let him know if there is anything up off that.
Okay. Let's set you back for another review hearing. September 12th. For review at 9 a.m.
All right, thank you.
All right, thank you. Casey Jackson. State of Ohio versus Casey J. Jackson, CRB 2510. Jackson's present. I'll just hand you the report. All right. Mixed bag report, Mr. Jackson, but it's not terrible, so you need to get back on track. Looks like you've done community service since you were last here. You're no problem. 9 a.m. for review. James Eastman. State of Ohio versus James Eastman, TRC 23-1864, AEMC. Mr. Eastman is present. here today. All right. Mr. Easton, we still have a significant amount of fines left, but you're starting to make some progress there.
Well, my check this week was only $120, so I'm struggling.
Well, you can certainly come work it off on community service.
I'm 3 hours north of y'all.
Well, they can work with you, and you may be able to work it off on community service.
Well, I've had, uncle and my mother's sick, and with my appointments, this week was only $120.
Okay. We'll set you a new review for September 12th at 9 a.m.
Okay.
Kimberly Jones? Kimberly Jones. The State of Ohio versus Kimberly Jones, appeared in 21-1057. Ms. Jones was cited to be in court at 9 a.m. Time's now 9:52 a.m. Thank you. There'll be a bench warrant to issue for failure to appear. Michael Jones. This is State of Ohio versus Michael Thomas Jones, appeared in 15-3586, appeared in 15-11-2582, CRB 19-585. Mr. Jones is present here today.
Just want to let you know, started a new job, Monday and Wednesday this coming up week. I'll be able to make it to community service, and I'll be able to pay $45 on my fine today.
Okay. Jones, I'll set you back for September 12th.
September 12th. All
You're
right.
making progress. Won't say you got a significant amount of things to do, but you've still got maintenance.
I think it's 40 hours community service still,
And community service still.
so I'll be able to knock 12 out next week.
All right. September 12th for you, 9 a.m.
Thank you, sir.
Thank you. Mark Wells. Mark Wells. State of Ohio versus Mark Wells, CRA 2753. Time was 9:54 a.m. Mr. Wells is cited to be in court at 9 a.m. He's failed to appear at this time, so there'll be a bench warrant to issue. James Fortney. State of Ohio versus James Fortney, PRC 2667, A and B, CR 21706. Mr. Fortney, I saw you did some community service since your last hearing. Looks like you completed the community service portion, but you're just down to $320. Wow.
Yes, sir.
Are you working currently?
Yes. I'm full-time at Walmart, so
Are you working tomorrow morning?
yes.
Okay. I'll set you back as well for September the 12th.
Yes, sir.
You're getting close.
Yeah, I'm trying to make progress. I would have paid more, but we got a new apartment and had to buy stuff for the baby that's incoming, so just,
That's okay. You're getting close, you're making progress. I think you're just down to $320 left as it.
Yes, sir.
Once that's paid off, you don't have to come back.
yes, sir. Thank you so much.
All right, thank you. Benjamin Hawk. It says State of Ohio versus Benjamin Hawk, CRB 22-181, PSC 20-2041, CRB 12-18, A and B.
I'll let you know I'll be here tomorrow for the community service. I just got back from my hitch, so.
One of the cases looks like you've got 30 hours community service left on, but and then another case, looks like all of your fines are paid off on those two cases, but you just have community service left.
Yes, sir.
All right. So tell me you're going to be here tomorrow for community service. I'll go ahead and order that then. You'll be here tomorrow for community service. And I'll set you back on September 12th
September 12th.
at 9 a.m. for review.
All right, okay. And what time tomorrow morning?
Mr. Cooper, 7 a.m., is that right?
7:30.
7:30.
7:30. All right.
7:30
Thank you, Your
a.m.
Honor.
See you then, thank you. There was another one. Ma'am, what's your name?
My last name is Slack, but it was Rayburn.
Okay.
It's just, yeah, it's me.
Okay, we had a file that got stuck in with another one, and we need
Yes,
to
sir.
make sure. All right, this is State of Ohio versus, is it Caroline?
Slack. The case is under Rayburn.
Sure, that means your first name Caroline?
Carolyn.
Okay. I couldn't tell by the way it was written.
That's okay.
I was asking, I didn't know.
Yes, sir.
All right, this is State of Ohio versus Carolyn Rayburn, CRB 1218A and B. Ms. Rayburn is present. It's not Slack. All right. Well, you're making progress, and
I have $50 to pay towards my fines.
you're making progress, you're almost there, and you're doing along your treatment. So I'll set you back for September 12th for review at 9 a.m.
Thank you, sir.
Thank you.
Hold more reviews. Caleb Banker. Brittany Balco. Sermon Brown. Devon Leonard. Michael Miller. Otis Sexton. Scott Taylor. LaDonna Walker. Vicky Scarberry. Amber Martin.
That's Caleb Baker. The State of Ohio versus Kyle Baker, CRB 24-754. Mr. Baker, it looks like you're down to $325 left on this, and 3 hours of community service is all you got left.
Your Honor, if I may, he turned to 3 hours of community service this morning, so it's not.
Yeah, and I should be down to 275 because
That's already
that,
made payment as
yes.
well. So I'm going to set you back for September the 12th.
okay. And is that a Friday, Your
That
Honor?
is a Friday.
Okay.
For review at 9 a.m. Brittany Balco.
Yeah, here.
All right, this is State of Ohio versus Brittany Balco, TRC 24-144 A and B. Ms. Balco is present via Zoom today. Ms. Balco, I saw you did 6 hours of community service since your last hearing, and looks like you're down to 18 hours left and $545 in the fine. You're making progress, which is what we want to see. I'll set you back for September 12th for review at 9 a.m.
Okay.
All right, thank you.
Thank you.
State of Ohio versus Sermon Brown. The State of Ohio versus Sermon Brown, PRC 24-1807, A, B, and C. Mr. Brown, you turned in a substantial amount of community service. Looks like it's all your community service is finished.
Yes, sir.
You're down to just a balance of $870.
Yes, sir.
If you want to work that off.
Yeah, that's what I plan on doing.
Any way you can make it tomorrow?
Yeah, I can play it tomorrow possibly. What time? Is it 8 still?
7:30.
7:30.
Okay, perfect. All right, Mr. Brown.
And I have $30 to pay today too, so.
Okay, perfect. Once you get that knocked out, you won't have to come back. So
All right.
you're making some substantial progress, which is excellent.
Nice.
I'm going to give, since you're making such good progress, I'm going to go out a little further on yours. It's got October 24th. So Mr. Crawford will say be here at,
He was with the OVP Recovery Center, but he left A&A.
okay. There'll be a bench warrant issue for failure to appear immediately. Thank you, Mr. Knight. Devon Leonard. Mr. Leonard, you've got another case today. It's out a little later in the docket, so we're just going to recall yours at that time. and do them all at one time.
Okay.
That way your attorney will be in and we'll deal with it all at the same time.
Thank you.
Thank you. Michael Miller. The State of Ohio versus Michael Miller, PSC 2113 A and B. Mr. Miller is present here this morning. This is an excellent report, Mr. Miller. You're doing fantastic. You got in 18 hours of community service. You still got a fair amount to go, but you're getting there. You're down to it. So it sets you back September 19th for review at 9 a.m.
You said 9 a.m.
Yes, sir.
All right, thank you.
Thank you. Otis Sexton. State of Ohio versus Otis Sexton, CRC 24-770. Time is 10:03 a.m. Mr. Sexton was cited to be here at 9 a.m. He's scheduled to appear. There'll be a bench warrant issue. State of Ohio versus Scott Taylor. This is PRC 24-1941. Mr. Taylor is present here this morning. Thank you. All right. Taylor, are you still in treatment?
Yes.
Okay, you have a report?
Yes.
Looks like that's all you got left, is just completing it.
Yeah, I'd say, usually Judge Capper, handles this and thinks it's a month-to-month thing, so it's been like a year and a month, I think, or 2 months.
Set you back October 24th for review at 9 a.m. Keep doing what you're doing.
All right, thank you.
Thank you. LaDonna Walker. State of Ohio versus LaDonna Walker, PRC 24-609 A and B. Ms. Walker is present here today. Looks like your community service is done, and you're just down to $250 left on your case.
I'm gonna pay $100 today.
Okay. If you want to save some money, we need community service workers.
I've worked all the community service I can work. I got it down from 600 to 250, so, and I have 2 jobs now, so it's kind of hard to get over here.
Okay. I'll go ahead and I'll set you out a little further to October 24th.
October 24th.
For review at 9 a.m. If you get it paid off by then, you're finished. You won't have to come back.
Okay, thank you.
Thank you, Ms. Walker. Vicky Scarberry. Let's see, the State of Ohio versus Vicky Scarberry, PRC 24-72 A and B. Ms. Scarberry is present here today. All right, very good report. I'll set you back for September 26th for review at 9 a.m.
Thank you, sir.
Amber Martin.
Yes, sir.
All right, State of Ohio versus Amber Martin, CRB 19-585. Ms. Martin is present via Zoom here today. And Ms. Martin, you're down, it looks like. Are you still at the Oxford House?
Yes, sir. I am actually the president and the HRC and the comptroller here at the new house. So we opened up a new house and I got it started for them.
Well, you're doing exceptionally well. You're down to $285 left is all you got left.
Yes, sir.
So you're moving right along. I'll set you back for September 26th,
Thank you.
and that'll be at 9 a.m.
Thank you, sir.
Thank you, Ms. Martin. Next group of cases we're going to call are arraignments. That's first appearances on cases. Likewise, when you hear your name called, come down to the table on your right, my left, and we'll go through the case. I will inform you of the charges, go through the penalties associated, possible penalties associated with those charges, and you can enter one of 3 pleas. You can enter a plea of guilty, which means you're making a complete admission that you committed the offense charged. You can enter a not guilty plea, which means you're not admitting, you're entering a denial at this time of the that you committed the offense charged. Or you can enter a no contest plea. No contest plea means you're not admitting that you committed the offense, but you're not contesting the facts surrounding it. And if I believe that the state would have enough evidence, I can enter a guilty finding. If you were unsure of what you should do, you should enter a not guilty plea. It preserves all of your rights before the court. You have the following rights before the court. You have the right to remain silent. Anything that you say in here is being recorded. And if you say something that is against your interest, then the state of Ohio, who is listening, and the representative is listening in the back, can you get a copy of that and use that against you at a later date, at a trial? You have the right to have reasonable bail set. You have the right to have counsel. If you can't afford counsel, I'll appoint counsel for you if you wish. And then you have the right to force the state to prove each and every element of each offense charged beyond a reasonable doubt. You would call the first case.
Your Honor, we're calling Amanda Hyten.
This is State of Ohio versus Amanda Hyten, CRB 25447. Ms. Hyten is being handed a copy of the charges at this point. Ms. Hyten, it's alleged that on or about July 22nd, 2025 in Fayette Township, you did knowingly cause or attempt to cause physical harm to Gary Arball, family or household member. That's an alleged violation of Ohio Revised Code 2919.25A. That's domestic violence. It is a first-degree misdemeanor. The maximum penalty associated with that is up to 180 days in jail and up to 6 months in jail and up to $1,000 fine. How do you wish to plead?
Not guilty.
I'll accept your not guilty plea. Can you afford to hire an attorney?
No, sir.
Okay, are you working?
No, sir.
All right. I'll find that you qualify for appointing counsel. I'll appoint attorney Roger Smith. I will continue your bond that you've already posted. Is there going to be a protection order?
Yes, Your Honor.
Okay. All right. Ms. Hyten, at least for now, there's a temporary protection order requested in this matter, at least for now. I know you've already signed as part of your bond that you can't go around Mr. Arball, but there's going to be a protection order issued. You can't have any contact directly or indirectly, social media.
So I do have a question.
Probably want to ask your attorney first.
Okay.
And he'll be able to guide you through that process.
Thank you, Judge.
All right, thank you, Mr. Smith. Ms. Hyden, we'll see you back on August 27th.
Yeah, do just a second, go to the lobby. I'll be
Thank
right
you.
there.
Thank you.
Heather Kincaid.
The State of Ohio versus Heather Kincaid, COB 25-386 AMB. Ms. Kincaid, have you received a copy of your charges?
Yes, sir.
Okay. All right, in the A case, Ms. Kincaid, it's alleged on or about June 16, 2025, in Fayette Township, you had failed to file withholdings during which an employer directly and indirectly or constructively pays compensation to your credits, compensation to the benefit of an employee in violation of Section 5747.07 of the Ohio Revised Code. That's failure to eliminate taxes. That's an unclassified misdemeanor. Maximum penalty is up to $1,000 fine and up to 500 hours of community service.
Yes, sir.
In the B case, it's alleged on or about June 16th in Fayette Township that you did fail to file in your return or report required to be filed by this chapter or file or cause to be filed in your complete false or fraudulent return report or statement. So aid or abet another in filing of any false or fraudulent return report or statement. That's an alleged violation of Ohio Revised Code 4739.30. Failure to file sales tax returns, that's also an unclassified misdemeanor. The maximum penalty on that is up to $1,000 fine and up to 500 hours of community service. Now, neither one of these offenses are jailable offenses, which means you're not entitled to appointed counsel because the liberty is not in jeopardy. So we'll start with, how do you wish to plead to the charges?
Guilty, sir.
All right. So you're making a complete allegation that you committed the offenses charged. All right, I'll accept your guilty plea. I'll enter a guilty finding. Mr. Heald, is there
Your Honor,
a recommendation from the state in this matter?
Yes, Your Honor. The enforcement officer was here this morning and filled me in a little bit on this, and he did not have any unkind words for Ms. Kincaid. However, he said that throughout the years they've had a little bit of a problem with on and off with compliance, and this was the end result of giving them a number of different opportunities of which they've caught up at times and gotten behind at times. His request of me was to ask the court for a $100 fine on each of the offenses and court costs. So one court costs and a $100 fine on each consecutive would be our recommendation.
Okay. Ms. Kincaid, are you working presently?
Yes, sir, this is my business.
Okay. Let me ask you this, do you work tomorrow?
Tomorrow? Yes, I am working tomorrow, sir.
Okay, in the morning?
Yes, all day, actually.
All right, I will accept the state's recommendation in this. On the A case, it'll be a $100 fine. I'll order you to pay the court costs. And on the B case, I'll order a $100 fine on the B case. And I'm not going to order any probation, but I will set your review hearing to make sure that you get that paid. I'm going to set your review hearing for January the 30th of 2026. If it's all paid by then, you don't have to show up for that. Your case will be closed out at that time.
Yes, sir.
All right. Ms. Kincaid, you'll need to see the clerk before you go. Thank you very much.
Thank you. Out here, clerk.
Just move out and then to the right.
Okay, thank you.
Thank you.
Joseph Sherman. Joseph Sherman.
So the State of Ohio versus Joseph Sherman, CRB 25-387 A and B. Matter was scheduled for an arraignment. Mr. Sherman was scheduled in the court for 9 a.m. The time is now 10:17 a.m. He's failed to appear and there'll be a bench warrant issued.
Jared Stover.
This is State of Ohio versus Jared Stover, CRB 24-461. Mr. Stover is now present and it appears that On 7/18/25, it's alleged, Mr. Stover, that you had failed to appear for a review hearing, and there was a bench warrant issued at that time. Do you admit or deny that you failed to appear for your review hearing?
Admit.
All right. Do you have a good reason why you weren't here?
For some reason, I thought it was on the 26th. I realized early this week that 26th was on a Saturday, so I came today. I do heating and cooling. I'm a service tech, and my work's just crazy, and I really don't have an excuse.
All right. Well, all you're down to is your treatment, so it looks like you paid a substantial amount of either fines, costs, or restitution, or all of the above. And you're doing well in your treatment. I believe the day that you were here, the treatment provider went back for you a little bit, so that's going to work in your favor. And the fact that you're here today with a good report. So we'll call the warrant, and I'm going to set you another review date for September 26th.
Okay.
At 9 a.m. You'll be back on the regular review docket.
Thank you, Your Honor.
Thank you, Mr. Stover.
Justin Lambert.
State of Ohio versus Justin Lambert, CRB 24-652. Mr. Lambert is present here this morning. Mr. Lambert, have you been provided a copy of your charges?
Yes, sir.
All right. We've also been handed a report here that Mr. Lambert is in treatment. And Mr. Gill, it looks like this is an old case, but I don't know if you've got it. It appears that the 2020, August 20, or October 2024 case, doesn't appear Mr. Lambert was ever arraigned on that. You're doing great in your treatment. Looks like you've got a completion date, so it looks like you're almost finished. So we'll go ahead and handle your arraignment at this point. Mr. Lambert is alleged on or about September 29th of 2024 in Fayette Township. It's alleged that you did by threat of force knowingly caused Brian Lambert, a family or household member, to believe that you had caused imminent physical harm to Brian Lambert, a family or household member. That's an alleged violation of Ohio Revised Code 2019.25C. That is domestic violence, a misdemeanor in the fourth degree as charged. Misdemeanors in fourth degree carry a maximum penalty of up to 30 days in jail and up to a $250 fine. How do you wish to plead?
No contest.
Mr. Gill, with this being an old case, do we even know that anybody's wishing to pursue this at this point?
Your Honor, I think that's where Jasmine went to get the file. We weren't aware this would be called, so I don't know anything about it at this point.
All right, we're going to recall this in a few minutes. Before I accept your no contest plea, we're going to let the state get the file, take a look to see if this is even, where it's an older case, whether someone can even look and pursue this anymore.
Yes, sir.
Before I accept that no contest plea, any moments.
Wesley Wright.
Wesley Wright.
That's one of the jails. Yeah, it just got exported.
Okay. We'll recall that as well. We'll put with the jail.
Laurel Jeffries.
This is State of Ohio versus Laurel Jeffries, CRB 25-449. Mr. Jeffries is present. Looks like he was just handed a copy of his charge. All right. Mr. Jeffries, it's alleged that on or about July 22nd, 2025, in Union Township, that you did knowingly cause Bruce Jeffries to believe that the said, or that you would cause serious physical harm to the person or property of Bruce Jeffries. That's an alleged violation of Ohio Revised Code 2903.21. It's alleged as aggravated menacing. That is a misdemeanor in first degree. Maximum penalty is up to 6 months in jail and up to $1,000 fine. How do you wish to plead?
Not guilty.
All right, I'll accept the not guilty plea. And I will continue the bond that you've already posted.
Can I ask a question about this?
You may, but let me ask you.
I'm okay with asking a question.
Okay.
Can I request that this be dismissed?
You can talk to the prosecutor about that, but that's a formal motion, and they just the arraignment on that. You have money to hire an attorney?
I do, and I have one on standby. I just assumed that, based on what the charges were, that it would be dismissed since I know that it's false. I'm in Columbus, and traveling down here is pointless for something that was alleged, but was false by nature, so.
What Mr. Field wants to address.
The alleged victim in this matter, his name's Bruce Jeffries. Guessing that's a relative.
It is.
Allegation is, if it were true, is serious.
If it were true, it's very serious.
Your Honor, if you want us to, we'll try to make contact with him. We call the case. If that's, otherwise, we can do it between now and the next hearing.
Why don't we do this? I'll accept the not guilty plea, and I'm going to enter that for you, Mr. Jeffries. I'm willing to set a pretrial on this matter out in August. However, you can appear via Zoom for that pretrial. That'll give the state an opportunity to reach out, see if this is something that they're going to pursue or not pursue. And I will disclose at this point that I would have a conflict here in this case and anything other than the arraignment. I know both parties involved. And so I think the appropriate thing to do would be to set it for a pretrial, and then Judge Capper's going to be here, and then that way they'll have an opportunity to look at it, to verify the veracity of the claims, or whether there's something that is even wanted to be pursued, and Judge Capper can ultimately make a call on that.
All right, and who and how would I make contact with someone without an address? At the current time, I wouldn't be able to get mail.
So you would need to speak with clerks about getting the link to be able to get on Zoom. And then that way you can appear via Zoom if you're in Columbus. I don't know if that makes sense to have you drive down here for that.
Okay, but in the meantime, because I have a feeling that if they were able to contact them, it's going to be, they're not going to pursue it. So in the meantime, so how would I hear between now and then?
It likely probably wouldn't get dismissed until the court date if that person would do that. So, but you'll be on Zoom, and if it gets dismissed, then the case is done at that point. If it doesn't, then you'll take it up from there going forward.
All right. Can I ask another question?
No.
I'm sorry for being complicated, but also my children, my wife, all of our things are in that household, and I would like to be able to go back there and get my things.
I don't know if the state's requesting a protection order at this time or not. I guess in theory there would be nothing that would really stop his wife from going and getting things if there was, or even if there was a protection order. But as part of your bond, I think it was listed that.
There was one that I looked at. There was a protection order, I guess I could pay someone to go remove the things. I just know that she won't be able to remove them, so.
We are going to request a protection order, if that's the question at this point.
Okay. All right. Mr. Jeffries, it's court standard policy, at least until they contact, if they request a protection order, that we do grant that. It's also part of your bond, so it's kind of academic at this point. But that will also get taken up likely at the next hearing as well.
Okay.
Okay? So you just can't have any contact with police until the report.
All right.
All right, thank you, Mr. Jeffries. We'll see you back, I'm gonna set you back for, does a Monday or Friday work better for you? Or does either matter?
It doesn't matter, especially if it's going to be over Zoom, so. But to kind of go back to asking if I get my belongings, so I can send my wife to get my things?
There would be, presumably, there would be no.
Well, this is one that we could try to contact the alleged victim and find out if it's okay if Mr. Jeffrey's wife gets stuff from them.
Okay. I'll go ahead, I'm gonna go ahead and set this for August. Well, let's recall this here in a few minutes. We'll let them reach out first, because that may determine when I set this back. So if it's a situation where there's an issue, we're going to set it back a lot quicker than if it's a situation where there's not an issue. And we may have an answer on some of the rest of our points as well.
So recall, just go.
Yeah, just have a seat in the back and we'll recall it here.
All right.
If you got a pre-trial, you can go ahead and come in the courtroom. We need to get you.
Morning, Your Honor.
Judge, this is a case that's set for trial today. It's Tim A. Fortner.
This is State of Ohio versus Tim Fortner, CRB 25301. This matter was set as a trial at noon. Pre-trial. I'm not sure if Mr. Fortner's here or not, because it's early. Mr. Morford is present on his client's behalf, state's represented by Attorney Phil Fields. My understanding is, from speaking this morning, that the parties are not wishing to go forward with the trial today.
That's my understanding, Judge. I was just served with an update discovery containing 2 new witnesses that I haven't had a chance to interview. Okay. And I respectfully ask you to continue it for a short period of time.
My understanding is the state has no objection to that.
No, Your Honor. I spoke with Mr. Morford about that yesterday evening, and we determined that was the best thing to do.
Do you want to set this back for a pre-trial or set it again for a trial?
Judge, it might be beneficial to set it for a pretrial, you think?
Mr. Morford, how much time do you think you'll need?
A couple weeks, Your Honor.
What's your schedule look like in the middle of that? A pre-trial at 10 a.m.
State of Ohio's Charles.
The State of Ohio versus Charles Fricken, POC 24-1281-A&B. This is Mr. Morgan's case. It's set for a pre-trial on the vehicle swap.
Oh, they do, yeah.
That depends on them. I don't know if you can do it on one patient. As long as you took Judge, I'd like to continue the path he's on. He checked himself into inpatient from outpatient and wants to continue with that line of treatment, please.
I think that is a wise decision, Mr. Frick. Because as I was reading this, my thought was I may be revoking your bond today and sending you to jail, and then I got to the point where you came to the realization that you needed more help than what outpatient was providing, and that is very encouraging, and I'll certainly give you that opportunity to do so.
Thank you.
So, let's come back. I'll give you a little time to come back August 29th. That'll be a pretrial hearing. All right, take advantage of this, Mr. Frick.
I will, sir. Thank you.
Thank you, Your Honor.
Thank you, Mr. Moore.
Darrell Runyon, State of Ohio versus Darrell Runyon.
All right, this is State of Ohio versus Darrell Runyon, CRB 23529. This is Mr. Morphin's case, and it's set as a pretrial.
What happened?
I've been locked up for a year, so I've been incarcerated for a year.
You were in jail in July.
I was in prison.
Where?
In Silver Coffee. I feel better now.
That's one of the first things the probation officer looks at when you walk in. How you feeling? You got some weight.
Is he in treatment now, or what's going on?
On the phone. On the phone, I'm in treatment.
With him?
It's an app. I have asked my old lady. I'm not sure the name of it.
He was in prison.
Plus, I done some stuff while I was locked up too.
Well, we wanted to dismiss him after he finished his treatment with the payment of court costs, so we gotta find out what's going on there.
You do this one?
Yeah.
Judge, he's engaged in counseling by telehealth, I believe. I think that's one of Mr. Heald's concerns, is that he complete a course of treatment. I don't know whether that would be acceptable to the court or not. Can you tell me the name of it?
I don't know the name of it. My fiance got me on it, but I lost my phone. That's why I haven't been on it the last couple of weeks. Plus, I've been locked up and I've been doing stuff for myself.
Mr. Hill, thoughts?
Well, this is a 2023 case, and there had been quite a lapse there between the last time we saw Mr. Runyon and currently. Back then, in 2024, he was supposed to be going to treatment, and that was not completed at the time. So we'd like to know what kind of treatment he's doing, or at least get something from a provider that would say that he's done what he needs to do, or he doesn't need treatment anymore, that kind of thing. Way back when, we talked about a dismissal with the payment of court costs if he was successful in treatment. And that's been a while ago.
When do you expect to get a phone back?
I'm getting the phone back as soon as I get home.
I don't live here now, I live in Franklin County.
Where do you say you live, Mr. Morphy?
Franklin County?
Franklin County.
Franklin
Yes,
County.
sir.
Okay. I wonder if that changes any of the calculus on Mr. Hill or not. I was gonna have him assessed by someone here local in the back, but if he's in Franklin County, I don't know that we have anybody to assess him there.
Plus, I'm on probation down there, that's why I'm saying down there.
In Franklin County?
Yes, sir.
Well, it might be that we've done all we can do with this case, and perhaps it will be time to dismiss the case. But I think it would be a good idea if we had a chance to speak with the alleged victim and make sure that there haven't been any more problems. So if we could do that, I'm running Jasmine ragged this morning, so.
We can do that on another day. All right. Let's do August 11th. That'll be a pre-trial 10 a.m. If that works with your calendar, Mr. Morford.
I'm sorry, Judge?
August 11th.
Let me look here, Judge. I've got a bad August. I have a trial in front of Judge Finley then, Judge.
August 18th.
I'm in trial then too.
August 22nd, I know works.
Yes, I'm here then.
All right. It's set for August 22nd at 10 a.m. That's going to be a pre-trial. Mr. Rundon, the state's going to reach out to the alleged victim in this matter, and it may be that there's a conclusion in your case at that point.
Okay.
Depending on what that conversation yields.
Thank you, Your Honor.
Thank you.
Thank you.
All right, I have another arraignment, State of Ohio versus William Cottle.
All right. Got another arraignment, William Cottle. This is State of Ohio versus William J. Cottle, here, 25 EB 12 A and B. Mr. Cottle is present here this morning, and then there's also COB 25-448. Mr. Cottle, it's alleged that on or about July 21st, 2025, this is PRC 25-18-12 A and B, in Rome Township, you were operating a motor vehicle while under the influence of alcohol or drug abuse or a combination thereof. That's an alleged violation of Ohio Revised Code 4511-19A1A. That is a first-degree misdemeanor. Maximum penalty on that is up to 180 days in jail, up to a $1,375 fine, up to a 3-year license suspension. And the minimum penalty on that is up to 3 days, the minimum penalty is 3 days in jail or 3 days in a driver intervention program, a $575 fine, and a 1-year license suspension. There's also the B case, is failure to control. It's an 2-1 glass plastic residue. That's an alleged violation of Ohio Revised Code 2925-16C1, possession of drugs paraphernalia. That's a misdemeanor of the 4th degree. Misdemeanors of the 4th degree carry a maximum penalty of 30 days in jail with a $250 fine. How do you wish to plead?
No contest at this time.
All right, so you're going to enter a no contest plea. You're not admitting that you committed the violation, but you're not contesting the facts surrounding the violation. Now, you understand that this is a case that you could go to jail on.
Well, I was hoping that that was not be the case, but, because I got 80-year-old parents that I take care of.
Okay.
But
Well, here's what I'm going to do. I'm going to enter a not guilty plea on your behalf. Are you currently working?
no, but I'm disabled then.
Okay. All right. So I will enter a not guilty plea on your behalf. I'm going to appoint Attorney Butch Morford to represent you. I'll find your injury under Ohio's definition.
It's a paperwork.
Yes, sir.
And I'm going to note that he had insurance. Yeah, he would have probably filed. I will allow you to sign us, well, before we do a bond, I want to have them screen this before we do a bond. So is there somebody that can screen Mr. Cottle? All right. Mr. Cottle in the back, Jeremy of RRS, he's directly underneath the courthouse painting. Back there, he's going to do a urine screen on you, and then we're going to have you out to determine your bond at that point. So we'll recall this in a few moments. All right, we're going to go back to the pre-trial docket.
State of Ohio versus Joseph Barber.
Says, State of Ohio versus Joseph Barber, CRB 2585. Mr. Barber is present with his attorney, Mr. Roger Smith, and this matter is set as a pre-trial.
Just, excuse me, was contingent today for dismissal upon payment of cost. I understand he has paid the cost, is what he's telling me.
It does look like the costs were paid. Mr. Gill?
And Your Honor, we have no report of further problems, so we're okay with the dismissal.
All right, matter will be dismissed at state's request.
Thank you, brother. Take care of your man.
Barber, you're free to go. Thank you.
State of Ohio versus Adria Price.
This is State of Ohio versus Adria Price, CRB 24693, CRB 2557. Mr. Roger Smith's case set as a pre-trial.
Judge, we were here last week. This case has a long history, and I was not aware that Judge Cap would not be here. We set it for today to make sure that she got in past. She says she has an appointment on Monday.
Yep, at 9.
At 9 o'clock Monday morning. If we could come back any day but the 18th or 29th in August, as soon as you want to do it. We should have some type of report from past saying how she's doing and she's actually
August 4th?
in service. Yes, sir.
August 4th.
August 4th.
You said August the 4th at 10.
10. And then make sure they have release, they can send the report to the court. Sounds good.
Defendant's request this matter will be continued to August 4th at 10 a.m.
Thank you, Judge.
Thank you.
We're going to need Sean Stratton.
All right, Mr. Stratton, you're up. Yes. You've got the rest of the pre-trials.
You've got the rest of the pre-trial.
State of Ohio versus Elias Blankenship.
State of Ohio versus Elias Blankenship, PRC 251687 AMB. This is Mr. Stratton's case set as a pre-trial.
Your Honor, the state has offered Mr. Blankenship to plead out the OVI. I don't think we're in a position to do that today. So we would like to set this for another pretrial, and if the state wants to set it for a trial, we'll set it for a trial.
All right, how far out are you looking, Mr. Hill? Would you rather it be set as a pretrial or trial?
Well, a trial, if the pretrial, there's no reason to have further discussion, then I guess we have a trial.
Okay. All right, how far out are we looking, gentlemen? I mean, Mr. Hill, I know you're here every Monday and Friday.
Your Honor, not the 4th, 11th, and the 18th, but any other time would be fine.
22nd?
The 22nd? Yes.
Mr. Hill, does that give you enough time?
Well, the only thing I have to do is check with the trooper to make sure that he's available on that day. So we're okay with August 22nd.
This was a first pretrial on this, and so there's no time issue on this case.
You sent that for a trial on the 22nd, Your Honor?
August 22nd for trial at noon.
All right, thank you.
Thank you.
State of Ohio versus Alicia Connor.
State of Ohio versus Alicia Connor, CS 25-327, AAP.
Your Honor, the state has offered a plea on this, and an offer of 180, recommendation of 180, suspend 175, 5 days in jail. That's unacceptable to Ms. Connor, so we're going to set this for trial too.
August 29th.
Did you say the 29th?
Yeah, is that what you're counting, Mr. Kraft?
Yeah, that's fine, Your Honor.
All right, Mr. Hill, does that give you enough time?
We'll talk soon.
August 29th should be plenty.
Thank you.
August 29th for trial at noon.
All right, thank you, Your Honor. We'll talk soon.
State of Ohio versus Charles Hawley.
State of Ohio versus Charles Holly, CRB 25-383, CRB 25-377, CRB 25-368. So Mr. Stratton's case settles for trial.
Your Honor, Mr. Holly has been to RS. No services have been needed, so we're at an impasse here. The state hasn't indicated what the state wants to do. They have given no offer on this case, so that's where we stand.
Here's the alleged victim, may be present in court today as well, so I'll give Mr. Hill an opportunity to speak with her.
This is your state, your mom's house, is that right? Okay, and he comes and causes problems. Okay, well, I'll talk to the judge about that. I have to decide is we're gonna have a trial or we're gonna offer a way to settle this. If we said that we could go and stay away, we've got to suspend the jail sentence so that if you brought it to the court, you can go to jail.
We'll see what he says.
That'd be enough. Yes. Yes, that's what we were. Okay. So, Your Honor, I've had an opportunity to speak to your Amy, right? Of Mr. Holly continuing to, I believe, probably be in violation of the protection order. He goes to a place that is nearby and observes and watches the property where the victims are staying and living, and they consider it to be a violation of the protection order. In order to resolve this, we need for that to stop, number one. And number two, we would ask for a 60-day jail sentence suspended in order to stay away, if they're interested in doing that.
No, Your Honor, and if they believe he's in violation, the state should file charges against him, and we'll handle that matter when it comes. But that's not before this court, it's merely this case. We don't believe he's in violation of the protection order, Your Honor. I mean, it's not a violation that you see somebody and looking at somebody, but if the state believes that, file charges.
You on that, Mr. Hill? Gentlemen, where are we going from here?
We set it for a trial.
Mr. Stratton, August 18th?
Yeah, August what?
18th? Is that what?
No, that's a bad day. Yeah.
Bad days. August 11th?
The 4th and the 11th and the 18th, Your Honor.
All the Mondays, basically?
In August, yes, yeah.
Let's then do August 15th.
Yes, that'll work.
All right. So we set up a trial at
Well, okay. Yeah, it's outside the distance. I know where it's at. All right, you're good. All right, you're good to go, Mr. Charles.
State of Ohio versus Ernest Mayhem.
Your Honor, these cases are also outside the 10-day window for jury demands. They'll have jury demands with them shortly.
Take that up whenever we get them. If the jury man within time, you're certainly entitled to that.
Yes, Your Honor.
All right. So State of Ohio versus Curtis Mayhem, CRB 25-303.
We have,
Mr. Strack's case set as a pretrial, and looks like the lady and alleged victims in court and the rest.
Your Honor, this is in addition to two other cases that are, what's her name?
Andrew
and Nathaniel.
Nathaniel Mayhem.
Yes, so I believe we probably can address all those cases together, Your Honor.
Let's go ahead and call those as well.
He's still driving by my house all the time.
I know, but they want you to serve 30 days in jail for his behavior.
For his behavior.
State of Ohio versus Nathaniel Mayhem.
This is State of Ohio versus Andrew Mayhem, CRB 25-302. State of Ohio versus Nathaniel Mayhem, CRB 25-304. Mr. Andrew Mayhem is present. I had noted that he was in a higher council, and Daniel Mayhem is also present. I had noted he's higher council, but I don't see council with him.
I ain't had time. I literally just started a new job up in Upper Sandusky doing blacktop, so.
Okay. All right, we're going to look at addressing these matters and collectively, if that is what the state wishes to do.
So, Your Honor, the state offered for my client to plead to the charge, and I believe it's the same offer that is given to the co-defendants here, to plead to the charge and each of them to serve 30 days in jail. That's unacceptable to Mr. Mahan. I'm assuming it's unacceptable to the other two also. I think they need, I would like the other two to have counsel, either appointed or set up for another pretrial where they'll have counsel here. So I asked the court to address that issue. But as for us, we're not accepting that offer.
Okay. Start with Andrew.
Yes, sir.
You have the money to hire counsel.
No, I don't.
Are you working?
Yeah, I just started working again at a paving company up in Upper Sandusky.
Okay. Are you paid hourly?
Daily.
Daily? How much do you get paid daily?
$150.
How many days a week do you work?
6.
You have any dependents?
No, sir.
All right, you're not going to qualify for appointed counsel. Mr. Nathaniel Mayhem, are you working currently? No. You're not working at all? All right, you wish to have counsel appointed?
Yes.
Okay. I will appoint Attorney Butch Morford to represent you.
Much money.
That's good to be. Huh? I believe the gentleman already has.
Yeah. Nathaniel.
What's your name?
Nathaniel.
All right, so I guess the question would be, where are we headed from here, given that Mr. Morford was just appointed, and I think Mr. Andrew Mayhem probably needs a little more time to hire counsel. Is that correct?
Yes, sir.
Mr. Mahan has some evidence that he wants to turn over to me, and we can divide if there's discovery demands filed. So probably another pretrial would be.
Yes, Your Honor, another pretrial. I bring it to the court's attention that Mr. Clarence Mahan has been driving by my client's residence. My client hasn't spoken to him, haven't communicated with him in any regards, but would you like to explain to the court what he's doing?
Your Honor, he keeps going by, flipping me off, revving his vehicle, hollering out the window, "I'm going to kill you, burn your house, and I'll get away with whatever I want to do."
Well, as your counsel so eloquently stated to the court, if you think that he's committed a criminal violation, then you're free to file charges, but that's what you have to stop.
Sure. Wait, just one second. One second.
I'm talking.
One second.
Yeah.
If you think he's committed a violation, you're certainly free to call the sheriff's department and file charges. That is within your rights. However, protection orders do not go both ways. So he can, while it might be evidence the opposite direction as far as if there was some alleged violation of a protection order at this point, that's not before the court. It might be mitigating evidence, but they don't go both ways. So technically, he can reach out to you, and if you respond, you're in violation. And that's just the state of the law. Whether you like it or you don't like it, that's the field we're playing on. But if you feel that he's done something wrong, you are certainly free to call the sheriff's department, file charges, and then the state would take up whether they think that something has been committed. And if it has and it comes before the court, we'll take it up then. But at this point, there's nothing you can do other than ignore it, and we'll call the sheriff's department.
Can we make a request? We cannot file a protection order against him without a physical address for him to be served. We need that to file a protection order through the court against him.
You'll need to speak with your attorney about that.
Okay.
Okay? All right, so I'm going to set all three of these cases back, and I want to give Andrew Mahan enough time to be able to get counsel, to get some money together and get counsel. So let's set this back for August 29th. And that'll be pre-trials at 10 a.m.
Your Honor, I think the court issued a protection order in this matter for Mr. Clarence Mahan, correct?
There are three protection orders in this matter. Yeah, all three cases, there are protection orders issued to the benefit of Clarence Mahan.
May my client have a copy of that protection order?
Yeah, once we conclude this hearing, Mr. Stratton, you're free to approach and you can take the files and make copies.
All right, thank you, Your Honor.
The August 29th, pre-trial at 10 a.m. You may. You just want the warrant or And Mr. Morford, if you want to approach and take a copy of the file.
Thank you.
So you can make a copy of the file. All right, I'll see you folks back August 29th. All right, we're calling William Clark. It's the State of Ohio versus William Giancarlo, 225-1812 A&B. This is Mr. Morford's case, and we recalled this matter on bond after a drug screen. Mr. Morford, have you seen the screen?
I have mine.
I think you're going to approach. So show that to Mr. Heal.
August 29th. August 29th.
What's up with this thing today, sir? You're positive for methadone, fentanyl, and THC. Okay, well, do you have a script for fentanyl?
No, I do
Or methadone?
Yeah, I do.
Where is it?
I don't have it on me.
Get it?
Yeah, I don't have it on. Can you get a copy of it?
I do.
I can get a copy.
Oh, I got to recall on that.
Okay.
Poses a little issue, Judge.
I see that.
He says he has a script for the methadone, methadone, but he does not have that with him.
Okay. Well, the methadone really isn't what's concerning me right now.
I know the second one is most concerning.
The second one is the most concerning because people don't typically die from methadone, but people die from the other substance. And I'll be real honest, Mr. Powell, I had some concerns as you were standing there, whether or not, part of the reason I didn't accept your no contest plea and entered a not guilty plea on your behalf was, quite frankly, I was a little concerned that you may be under the influence right now.
Oh, I did those before I came here. You don't need to say anything more.
All right, so here's what I'm going to do at this point. I'm going to, Mr. McCann, you did the urine screen on him. Do you want to do an assessment?
Insurance purposes, you need to go to table.
Okay, he's got
West Virginia.
West Virginia.
Yeah, it's been over there.
Is there anybody here that could do an assessment that would be able to?
OVP's out there.
Okay, if you want to have Brianna come in, Mr. Brown. Mr. Mint, would you be willing to do an assessment for it?
Yes, we can do an assessment. I was just explaining to Butch that we just may not have a methadone bed open today, but we can get the assessment done and get it in as soon as one opens up.
Okay, yeah, I'm a little more concerned, I don't know if have you seen the drug screen?
Yeah, I've seen his results.
Okay. And that's what concerns me, plus what was said in here today.
Yes.
So let's recall this again here in a few minutes. I'm going to have Mr. Powell, I'm going to have you assess, and then we'll determine what's going to happen from there.
Okay.
Thank you, Judge.
Thank you, Your Honor.
Good. That's yours.
Thank you, Sean Stratton. State of Ohio versus John Wellman.
The State of Ohio versus John Wellman, CRB 24444. This is Mr. Stratton's case,
He'll probably sit there and look to see how it's going. How you doing?
Doing all services, we wouldn't be able to complete him because of alcohol and THC.
I know that was the issue back on 623, but has that changed any from then?
If you would, he's actually, if you read, he asked for his counselor to remain, he could just be sentenced.
Oh.
And you continue to do services. He just feels like every hard day's work, he should go home and have a beer, it's there, which I get it.
I get that too. I get that. Okay. Hold on a second. So where's the plea trial? We have to play that.
Right. How's he doing?
So, you would have pleaded 2 sentences. What did you get?
30 days suspension.
If you pled out to the charge, it would be just suspended time, okay? You'd be on probation though, and the issues you have here will now become an issue on probation. So I don't know if you just want to try continuing treatment and maybe try to resolve some of these issues here to get completed on this, at least for, or if you want to plead to the charge and then be put on probation. There was some reporting requirement of some kind. Like that's up to probation. But if you continuously testing positive for these two things in probation, you'll have to report more.
So if you're still saying that's the problem.
That's the problem. That's the problem from you completing is these two substances. If you resolve that issue, it's pretty much going to be completed at some point.
Yeah, she said that, yeah, she said she was, but if not, you will see a PO and you could PV, probation violation. And that
Be
could
revocated.
And that could be serious.
Yeah. I suggest you stay with us.
Yeah, that's why.
Your Honor, we're still got some things to work on with RRS. I believe he is near completion. There's just these two issues that we need to address. Once he gets those addressed, he'll be completed and this will be dismissed. So,
Mr. Wellman, I'm going to address you directly on this. I'm going to address you directly on this. So,
Your Honor, you have a little bit of a hearing, so to speak.
all right, Mr. Wellman, can you hear me?
Yes.
Okay, I'm going to address you directly. So, you've made significant progress in a lot of ways here, but in some ways you haven't. And you're close to completion, but what gives me some concern here, Mr. Wellman, is and I applaud you for being honest about it, but when you say, you explain to your counselor that you work every day and you're not going to deny yourself a beer with dinner, you're telling me that you're not taking this seriously. And
I did take it serious.
And if you're taking it seriously, you'll know, as they said, you're basically, if you can test negative for 60 days, you're done. And, when you're saying those things, you're ordered by the court to be there and do those things and to be drug and alcohol free at this point. And when you're saying you're not going to deny yourself a beer with dinner, what you're telling your counselor, that's the same thing as you walking in the court saying, Judge, I don't care about your orders. I'm going to do it anyway. And you've got an opportunity to get this dismissed when you're saying, I'm going to do what I want to do. Well, again, we're fresh out of what you want to do on this. So if it's not a better report next time, there's going to be consequences. Do you understand that?
Yes, sir.
Okay. Mr. Stratton, how far out do you want to go to give him some time?
It's up to the court, probably a month.
All right, let's. Are you free September the 5th?
I'm sorry?
September the 5th?
Yes, that'll work.
All right. I'll set this for September 5th, free trial at 10 a.m.
September 5th. All right, here we go. Yep.
State of Ohio versus Kiefer Wilson.
This is State of Ohio versus Kiefer Wilson, CRB 25-462, CRB 25-162. It's Mr. Stratton, case is set for free trial.
Good. Mr. Wilson is in RRS, so we'll have a report here momentarily. Yeah.
Very good report, Mr. Wilson. Stratton, where are we going from here?
Your Honor, he just went in on Monday, and we just ask that we continue.
All right. Let's set this back for a pretrial on September 5th at 10 a.m.
It's not too far away, guys. All right, you good? Thank you.
Just call it an arraignment.
State of Ohio versus Stephen Boyd.
So the state of Ohio versus Stephen Boyd, City 25-450, Mr. Boyd is present. All right, Mr. Boyd, it's alleged on or about July 21st, 2025, in Fayette Township, you have known the cause or intent to cause physical harm to either Cornwell, a family or household member. That's an alleged violation of Ohio Revised Code 2919.25A, domestic violence. It's misdemeanor, first degree. Maximum penalty on that is up to 6 months in jail and up to a $1,000 fine. How do you wish to plead?
Not guilty.
I'll accept your not guilty plea. I'm going to continue your bond that you've already posted.
Also, sir, since I'm here, I would like to file an EPO on her.
That's not in the pure purview of this court. You're going to file a civil protection order that has to be done in the court, a common police court, not in.
Okay.
Are you going to hire your own attorney?
I can't afford one right now.
Okay, are you working?
Yes.
All right, are you paid hourly?
I'm paid by the day.
By the day, how much do you get per day?
150, if I make my bonus, 180.
Okay, how many days a week do you work?
Anywhere between 5 to 6 days a week. I have 2 dependents.
You're close. I'm going to find that you qualify. I'll appoint Attorney Sean Stratton to represent you.
I'm going to ask for a protection order too.
At the state's request, there's going to be a temporary protection order issued.
Do you need that residence?
Yes, this is mine. These are the she's been sending to some of my co-workers.
So does she live with you?
Mr. Boyd, it was already a part of your bond, but based upon the temporary protection order that's going to be issued today, it's going to be reviewed on another time. You can't have any contact either directly or directly with Dean Ford. Okay? All right, Mr. Stratton.
So this is your address.
I'd rather have this back sooner than later if we could.
She was in the process of moving out.
Okay, she's moving out? I'm sorry, Your Honor.
August 15th.
August 15th is good, Your Honor. He indicates that she is moving out of the residence at 1877.
She is also in maintenance rates too. That's fine.
Address that. If she's made threats, then we'll file a police report too. So I ask, Your Honor, that he'll be allowed back in the residence. She's apparently vacating that.
Mr. Beal, I don't know if you have any information about that or not at this point.
I don't have any information about, Your Honor, that obviously if she moves out, then I guess the only restriction we're asking for is that he stay away from her.
Okay.
He has no problem staying away from her, Your Honor. She apparently is not here today.
Well, what I want to avoid is a situation where she's not completely moved out and Mr. Boyd shows up and then we've got a real problem at that point. And that's what I want to avoid. I mean, I don't have any, evidence one way or another whether.
Well, I have had some mutual friends.
Careful what you're talking about. Oh, be careful.
I have had some mutual friends of ours contact me so that they can get stuff for her son. I told them it was fine, and I gave them keys so that they can go and get in, and told them where it was at, and they went and done that. So I don't have no problems with complying with whatever needs to be done.
Okay.
Sounds like, Your Honor, there's a middle person here that's communicating. I guess when he receives the keys back from them, so you can go back to that apartment, there won't be any issues.
That sounds like it shouldn't be an issue. Because the order is just that you stay away from her. Now, if she decides that she's going back to the apartment at this point, then, you know, the order is you stay away from her. So, I'm gonna leave that to your little bit of your discretion, Mr. Boyd, at that point. There's no, if she shows up, you gotta go.
I understand.
Okay.
Oh, what was the date, Your Honor?
We're gonna come back on August 15th for pretrial at 10 a.m.
Okay.
We'll recall Laura Jeffries.
I couldn't get a hold of this dad. I'll have to message to call.
The state of Ohio, this is Laura Jeffries, CRB 25429. We had recalled this matter. The state was going to try to reach out to the alleged victim in the matter. And we hadn't set any date to see if this was a matter that was going to be pursued.
We were unable to make direct contact with Mr. Jeffries. Jasmine left a voicemail for him, and he hasn't called back. So,
well, what we'll have to do, Mr. Jeffries, is set this on another day again. You can appear via Zoom, and then that will hopefully alleviate your need to come down. And then in the meantime, with any good fortune, the alleged victim in the matter would contact them, and then that may be resolved that day. So I'm going to set it back for August 22nd. It'll be a pre-trial at 10 a.m. I'll make a note that you're going to be able to appear via Zoom. And there'll be a video issued presently.
Your Honor, I'm gonna give him a copy of the protection order also.
Good.
Thank you. You'll need to get a copy of the protection order.
Yeah, I just gave it.
Oh, you're going to get it? Okay.
Do I need to do anything out there? I'm good.
No, you're good to go, unless you want to go ahead and get the Zoom information for the next.
I'll go out there.
Thank you. Zoom, can you hear me, sir?
Yes, sir.
All right. Mr. Benson, it's alleged that on or about October the 7th in 2020, you have failed to appear for a review. Well, might still be an outstanding charge. Mr. Morford, are you going to be representing Mr. Benson?
I did earlier, Judge.
Okay.
I assumed that you would continue my appointment.
I will. It wasn't listed on the file, so I'll go ahead and appoint Mr. Morford, continue that appointment. It doesn't look like this case has ever been resolved from the best that I can tell from the file.
It's my understanding he'd been indicted, Your Honor.
2020 case, I can definitely look that up. Benson, is that correct? John
Yes.
Benson. So we have a 2020 possession and a 2020 failure to appear in common pleas court, and they both indicate that they're both open.
Okay. Well, it sounds like Bond is a little bit academic at this point here.
Yes.
Because he's going to be on the common pleas holder, at least presently. So, but this is a misdemeanor here, so I'm going to set a 2,000 OR bond here. So, Mr. Benson, you're still held on a common pleas holder for felonies.
Yes,
But
can I talk to you for a second?
well, when are you going back to court on that, or when are you going to court on that?
Well, I'm on parole from West Virginia, and they recalled a warrant, and my parole
told me to come to court on Wednesday. So I came over here on Wednesday, went to court like I was supposed to, and they arrested me on a FTA, felony 4, you know what I mean? So then they said they had an OBI one on me from Capitol Court.
Which is where you're, which is what you're here on now. I'm setting an OR bond on this case, but, are you gonna be able to bond out on your cases on the felonies?
Well, I'm trying to, I just needed to see how this went, because they told me I had to wait till I come to court for this, but I gotta get an ankle monitor on me to go to, because I'm on parole too in the state of West Virginia. I just got out of prison for 3 years, you know what I mean?
Okay.
So I don't want to violate my parole in West Virginia.
Sure.
So,
Well, I set you an OR bond, so you're not gonna be held here on this court bond.
all right.
Mr. Morford, when do you want to come back on these issues? I mean, clearly there's going to need to be some resolution at common pleas.
22nd be up, right, Judge?
That'd be fine. I'll recall the warrant here, if it hasn't already been. Set a 2,000 OR bond, and be reset for August 22nd, 10 a.m. for a pretrial.
Thank you, Your Honor.
And Mr. Benson, I've reappointed Mr. Morford to represent you in the matter here. He had you before, and so you'll need to get in contact with him as well once you get out. I'm not sure who's going to be appointed to represent you in common pleas at this point, but you'll need to stay in contact with your attorney. And I'll see you back here on August 22nd at 10 a.m. if you're out of jail.
Okay, 22nd?
22nd.
All right, thank you, sir.
All right,
Thank you, Judge.
We need Nathan Corby, State of Ohio versus Nathan J. Corby.
All right. Mr. Gorby, can you hear me?
Yeah, yes, I can.
All right. I'm acting Judge Brian Cremines. We're going to do your arraignment today. And first, I want to go through the possible pleas and then your rights before the court so that you understand those before we go forward. So, you've been charged with a misdemeanor here in this court. You can enter a plea to that of either guilty, which means you're making a complete admission that you committed the offense. You can enter a not guilty plea. A not guilty plea means you're denying that you committed the offense at this time. You can enter a no contest plea, which means you're not admitting that you committed the violation, but you're not contesting the facts surrounding it. And then if I think the state would have enough evidence, I could enter a guilty finding against you. If you don't know what you should do, you should enter a not guilty plea to preserve all your rights before the court. Do you feel like you understand my explanation?
Yeah.
Okay. You have the right to remain silent. We're recording this today, and you're appearing via Zoom. Mr. Heald, the prosecutor, is here in the courtroom, so if you decide you want to tell me something that is against your interest, he can use that against you, and he's going to hear you say it. You have the right to have counsel. If you can't afford counsel, I'll appoint counsel for you at no cost to you. You have the right to have a reasonable bond set in the matter. And you also have the right to force the state to prove each and every element of the offense charged beyond a reasonable doubt. Do you feel like you understand my explanation of your rights?
I do, yeah.
Okay. Mr. Gorby, it's alleged on or about July 24th, 2025, in Perry Township, you did recklessly violate a term of a protection order issued or consent agreement issued in another state, or another state violation of the Ohio Revised Code in violation of section 2919.27A3. That is violation of a protection order or consent agreement. That's a first degree misdemeanor. Maximum penalty on that is up to 180 days in jail and up to a $1,000 fine. How do you wish to plead?
Not guilty.
All right, I'll accept your not guilty plea and enter that on your behalf. Do you have money to hire an attorney?
No.
Are you working currently?
No.
All right, I'll find that you're indigent, you meet the definition. I'll appoint Attorney Roger Smith to represent you. And Mr. Hill, does the state want to be heard on the matter of bond?
Well, Your Honor, Ms. Mullins is here. It was her protection order, and she's trying to explain to me exactly what's happened.
Do you need a moment to speak with her?
No, I think I understand enough at this point. She petitioned in West Virginia for a protection order, but apparently Mr. Gorby had not been served yet at that time, but he was with her. That part of it, I'm not exactly sure about why that would happen that way, but she has requested in that court that the protection order be dismissed. She doesn't want the charges pursued. What we want to do is to be able to verify all this. We're okay with him getting out of jail today, and obviously she's not. At this point, I guess she doesn't want a protection order, so they can go about their business, although this is, if it's still pending, it can cause problems before we come back to court. And then we'll get to the bottom of it and decide what we need to do by the time we come back to court.
Okay. Mr. Gorby, did you hear what was said?
Yes, I did.
All right, I'm going to let you sign your own signature bond then. There's no PPO issue here out of this court. So I'll let you sign a $1,000 OR bond. All right. You'll be released from jail today. Now, there still is apparently a protection order, at least from what the information the court's receiving, out of West Virginia. And apparently, Ms. Mullins is wanting to dismiss that protection order, but it hasn't been dismissed yet, is my understanding. And so, that certainly can cause you problems going forward, but presently, I'm going to appoint Attorney Roger Smith to represent you. We're giving you an OR bond so you can get out of jail today. And Mr. Smith, when would you want to come back? Mr. Field as well.
Any day but the 18th or 29th of August is fine.
How long do you think you need, Mr. Field?
Well, I kind of understand more of it. So if she brings back proof that it's been protection order dismissed, then we're probably going to look at a dismissal at a later date. So we don't need to go out real far, I don't think.
You want to come back next Friday? Is that a week?
It's pretty packed, but we could.
Maybe
Could you do the 4th?
I could.
Okay. Let's do the 4th. The 4th is much better.
Hopefully this will not take a lot of the court's time nor energy, but you never know. 4th is fine, Judge.
We have pre-trial set at 10 a.m. August 4th. All right. Mr. Gorby, the state is indicating that if that protection order expires and they're providing proof of that, they're likely going to dismiss this matter, but it's going to be August 4th. You've got to be here at the court in Chesapeake August 4th at 10 a.m. for a pretrial. And hopefully there'll be some resolution on the case by that point.
No problem.
All right. We'll see you then. Mr. Gorby, once you sign the bond.
All right, thank you.
Thank you.
When are we coming back, Your Honor?
This is State of Ohio versus Emily Smith, and it's a pretrial, and Mr. Stratton is counsel.
Your Honor, Mr.
Let me go ahead and go until she's on there. So State
So
of
this
Ohio
is
versus
not
Emily
her.
Smith.
This is not her.
Okay. That is definitely not Ms. Smith.
Well, she's not available.
in the chair. She's next.
Okay.
Mr. Stratton has some information on Emily Smith. She's in Gowdy County
Right.
Jail.
Okay. This is State of Ohio versus Emily Smith, CRB 23627. This is Mr. Stratton's case. It was set as a pretrial, and the court's been giving some information that Ms. Smith is presently in the jail in Gowdy County.
Correct, Your Honor. She has a felony pending in this county. She was not brought up here today because we're waiting on a competency evaluation to be done in felony court, which we'll use in this court for our purposes also once that's done. So we just need to reset it.
How far do you want to go, Mr. Stratton?
Probably a month, Your Honor.
So let's do September, early September.
Okay.
Let's do September 5th. Yes, it is CRB 23627. All right, the claims request is going to be reset on September 5th for pretrial 10 a.m.
All right, thank you.
Thank you, Mr. Brown.
Your Honor, this is a preliminary hearing, and Mr. Sean Stratton is counsel, State of Ohio versus Tressa Stakely.
All right. All right, Ms. Stakely, can you hear us?
Yes.
All right, this is State of Ohio versus Tressa Stakely, CRA 25-425 and CRB 25-426. We're set for a preliminary hearing today. This is Mr. Stratton's case.
Your Honor, we have spoken about treatment in this case. Ms. Stakely does not want to go to treatment.
I will now.
You will
My
now?
understanding is, Ms. Stakely, you've had a change of heart.
What is it?
My understanding is you, after sitting in the jail for a few days, you've had a change of heart. Is that correct?
Yeah, I guess so.
Okay. Counseling center's interested in taking you in treatment if you're willing to go, but if you don't want to go, I mean,
What is it?
the counseling center's indicated they're willing to take you into treatment if you're willing to go.
Yeah.
Okay. All right, I certainly wouldn't have a problem with that. Mr. Stratton, Mr. Field, any thoughts?
Your Honor, they just allow her to sign on bond and go to treatment and set up for another prelim, maybe in a couple of weeks, to see how she's doing.
Mr. Field?
We're okay with that. Now, the aggravated possession charge is one that we want her to be successful in treatment. And if she is, then we wouldn't take it to the grand jury, and we would actually end up dismissing that charge. The other charge is a theft charge, which we will need to reckon with. We'd like for her and our lawyer to speak about that before we come back again and make a determination whether she would plead or want a trial. She's been in jail for a week, so on a misdemeanor theft charge, 2 weeks, we wouldn't be asking for any more jail time than that if she pled now.
Your Honor, we'll address that at the next hearing.
Okay. All right. Ms. Stakely, I'm going to amend your bond to a $5,000 OR bond, and it's going to be a release only to the counseling center for inpatient treatment. Now, Ms. Stakely, did you hear what the state has indicated here on the record today?
That I'm to go to rehab.
Well, but here's what they're willing to do. If you go to rehab and you are successful and you complete your treatment at the rehab, Mr. Heel has indicated they're going to be willing to dismiss your felony case. They're willing to keep it here and give you an opportunity to complete the treatment. If you complete it, they're indicating they're going to dismiss it. If you don't complete it, or if you leave treatment, I strongly caution you against doing that. But if you do, they're going to take it to the grand jury. There's going to be a warrant. You're going to get arrested again, and then you're going to be stuck dealing with felony court, and the penalties are going to be much higher. Do you understand that?
Yes.
Okay. All right, that'll be the court's order. When do we want to come back? We want to give her some time to get in the program, but I don't want to go out terribly far to make sure that it's going to go well.
Any date except the 4th, 11th, and the 18th.
Let's do the 22nd.
Okay.
There'll be a preliminary hearing at 10 a.m.
I had it. Yeah.
And are you intending to get her today?
Yes, sir.
All right. Mistakenly, they're intending to pick you up today. All those local paperwork, that's the intention. They'll sign it on and go pick it today. All right, thank you.
Thank you.
Here's Sean.
All right, one more jail case. All right. State of Ohio versus Wesley Wright.
Mr. Wright, can you hear me? You're muted. All right, can you hear me?
I'm muted.
Can you hear me, Mr. Wright?
Yes, sir.
All right. So State of Ohio versus Wesley L. Wright, PRC 25, 380 A, B, and C. And, all right, doesn't look like you've ever been arraigned on this, Mr. Wright.
I don't think so.
All right. So, it looks like from the file that Mr. Wright was cited to be at court on this on March 3rd of 2025, and then again on March 11th, 2025, there was a failure to appear for the arraignment, and a bench warrant was issued at that time. Mr. Wright, you admitted denying that you failed to appear for your arraignment.
Yeah, I have never got a notice or mail or anything. I got it back to like a red light. My boss showed.
Okay. Well, we'll go and do your arraignment.
Okay.
But first I want to go through your rights and the possible pleas you can enter. So we'll go through your ticket here, and you can enter a plea of guilty, which means you're making a complete admission that you committed the charged offense. You can enter a plea of not guilty, which means you're denying that you committed the offense charged at this time. Or you can enter a no contest plea. A no contest plea means you're not admitting that you committed the violation, but you're not contesting the facts surrounding it either. Do you feel like you understood my explanation of your pleas?
Yeah.
And if you don't know what you should do, then you should enter a not guilty plea because it preserves all of your rights before the court.
Is there any?
So you have this here. You have the right to remain silent against your interest. He's here listening, and he can use that against you at a later hearing. You have the right to have counsel. If you can't afford counsel, I'll appoint counsel for you at no cost. You have the right to have reasonable bail set, and you also have the right to force the state to prove each and every element of the offense charged beyond a reasonable doubt. You feel like you understand my explanation?
Yes, sir.
All right. Mr. Wright, it's alleged on or about February 25th, 2025, in Warren Township, that you were operating a motor vehicle under the influence of alcohol or drug abuse or a combination thereof, and then that you also refused a test. That's an alleged violation of Ohio Revised Code 4511-19A1A. Maximum penalty on that case is up to 6 months in jail, up to a $1,375 fine, and up to a 3-year license suspension. The minimum penalty on that is either 3 days in jail or 3 days in a driver intervention program, a $575 fine, or a 1-year license suspension. On the B case, it's alleged that you failed to control your vehicle. That's an alleged violation of Ohio Revised Code 4511.202. That is a minor misdemeanor. The maximum penalty on that is up to a $150 fine and court costs. On the C case, it's alleged that you were using, on the same date, same township, you were using a prohibited electronic device. That's an alleged violation of Ohio Revised Code 4511.204. That's also a minor misdemeanor. The maximum penalty is up to a $150 fine and court costs. How do you wish to plead?
I guess what would make this go quicker to please, just to get it done with right now? No contest, I assume?
You can enter a no contest plea if you wish. And then if I think the state has enough evidence, I could find you guilty if you do that. Do you understand that?
Okay, so the not guilty takes it to a trial?
It could go to a trial later, but it won't go to a trial right away. You want to enter a not guilty plea, and that'll preserve all your rights before the court.
Yeah, I'm just trying to get back home, get my house wrapped up, get sold up, so I'm going to say not guilty, and I'm not sure what to do.
Okay. Do you have money?
Get sold here.
No, it's okay. Do you have money to hire an attorney?
No, not currently. I'm trying to sell my house.
Are you working?
No, I dropped a maid from my uncle out of the flight vessel this weekend, so I might be able to do that.
Okay. I'm going to appoint attorney Sean Stratton to represent you.
Okay.
How many days have you been in jail?
Just 1.5.
I will find on the failure to appear, I'll find the contempt, I'll sentence you to 2 days, give you 2 days credit on that, so the jail sentence for the failure to appear is complete. Mr. Hill, you will be heard on the matter of bond.
I believe that when a citation such as this is issued, there is a summons as part of that. I know Mr. Wright explained that he never got a summons, but I believe he did. And so I think that there's at least some indication that he knew that he was supposed to be here and didn't show up. So we'd like the court to consider that in setting the bond.
Okay. Mr. Stratton?
Your Honor, I just asked you allow him to sign his own bond?
All right. Here's what we'll do, Mr. Wright. I'm going to give you a $2,500 OR bond, so you can sign your own bond. But this is what's going to be important. If you don't show back up to court on this, you're going to get a bond forfeiture. And then what happens at that point is, and you'll also get a warrant, but you'll get a bond forfeiture. And when you get picked up ultimately on the warrant, then you're going to have to pay $2,500 before you can even get a new bond. Which means you're likely going to sit in jail at that point if you don't show up.
So I'll get my court date today before I leave, right?
You are. We're going to set that right now for you.
Okay. Thank you very much.
Can you do the 25th?
Yes.
Okay. We're going to set this for August 25th. It'll be a pre-trial at 10 a.m. So you'll need to get in contact with Mr. Stratton, and we'll see you back on August 25th at 10 a.m. All right. Thank you.
Jail's finished.
Okay, we're finished up the jail.
State of Ohio versus Terracea Patton.
This is the State of Ohio versus Teresa Patton, CRB 18485. This is Mr. Smith's case. It appeared that back on July 3rd, there was a failure to appear for a pretrial at that time, and there was, Ms. Patton is now present.
Yeah, Judge, she had been at New Life, went to OVP to work on herself. The plan is to go back to New Life when she completes OVP.
Okay.
So it wasn't a willful, I'm just ignoring the court's order to be there. She was...
I read that in the
Okay.
report, so I will call the warrant.
Thank you.
We're going to set you back. You available September 5th? September 5th.
Should be, Judge. Let me double check. It's a Friday, yes, I am.
All right, we'll set you back September 5th, and that'll be a free trial.
Thank you.
Thank you.
Thank you. Good luck.
State of Ohio versus William Hargis.
All right, this is State of Ohio versus William Hargis, CRA 25178. Mr. Stratton's case, and it appears on Monday. Mr. Hargis had allegedly failed to appear for his primary hearing.
Your Honor, Mr. Hargis had the wrong date. He's here today. I have a letter here from OVP. The approach?
Good report, Mr. Hargis.
Thank you.
I will call the warrant, and we're going to set you back September 5th. And that'll be for a preliminary hearing.
Thank you.
All right, thank you, Mr. Hargis. You want to go ahead and write that down so you know your court date?
I'm ready. Yeah.
Thank you, Mr. Staff.
September 5th.
All right, thank you. Thank you, Judge.
All right. Good board.
Sean.
The following order is State of Ohio versus the following order. And this is Tyler Smith's case, but he's giving it to the
Did you get assigned to me? I know, yes.
This is State of Ohio versus Devon Leonard, CRA 25195. And there's also PRC 251619 A and B and CRB 2523 on review. We called them this morning, but given that there was another charge, we wanted to handle everything at the same time. We received a very good report.
Yeah, that's good.
From Mr. Leonard's treatment provider in the matter. And we're going to, and another position, he can no longer take cases here, so we're reassigning his cases.
Okay.
So we've reassigned you Roger Smith, who's a very capable attorney as well, to handle your cases, and so he'll be your attorney going forward.
Okay.
As long as I don't die.
It's true.
Again.
All right. Mr. Smith, I know you're just coming on, may not have even seen this, so I'll give you an opportunity to take a look at everything. The old cases are on review, I'm just going to keep them with the preliminary hearing. And Mr. Leonard, you're doing a great job in treatment.
Yeah, just get to come back today, Judge, I'll look at the file. He did, there's an OVI, I understand, is that correct?
I believe that one had already been entered a complete too, but maybe.
Okay.
Yeah, that's on review.
Because what he'd asked me was about potential for driving privileges. The only hiccup there would be he does not have insurance, but he's going to obtain insurance. I told him, until he's fully insured, you can't allow him to drive. But
once you've received your insurance, Mr. Smith, if you want to execute a privileges entry that indicates that upon proof of insurance being shown, we would certainly grant him privileges for that. So the entry can already be done. Then just, Mr. Leonard, all you have to do is provide the proof of your insurance to the court, and at that point, your privileges will be issued.
Okay.
Okay, that way you don't have to wait to come back.
No.
I'm gonna set this on September the 5th.
Paper right then to drive.
Okay.
I'm gonna set this for on September the 5th.
Yes,
I want to give you some time with it, and that'll be on all matters, even the review matters.
Yeah, give me a chance to look at the file.
And so we'll, September the 5th at 10 a.m. Mr. Smith, do you want to go and take the file?
If I could, Judge, I'll take it over today, so I'll be back Monday. Insurance, you can drive. Okay.
All right, thank you, Mr. Leonard.
Proceed to sentencing. State of Ohio versus Angela Spurlock. Mr. Wilson's case.
All right, this is State of Ohio versus Angela Spurlock, CRD 181327, CRD 181297, CRD 185558, CRD 1516. This matter is set as a sentencing. And it looks like it's on a large amount of reviewed cases, old cases that are reviewed.
Just review it.
Mr. Morford, what has your client done since the last year?
She has a small payment for you today, Judge, and she's getting ready to do community service, I believe.
Yes, I had to move. I moved out Lavalette, so I didn't have no way to get here. So I got lined up that I could get transportation to get here, because I got 11 days to do. And then I want to start working on my payment for the, doing more community service. But I'm all situated where I'm at now, and I got transportation. So, but I do have a little payment today, and I'll start making payments weekly or every other week or something.
Okay. Mr. Morford, September 5th, does that work for your calendar?
I believe so, Judge. Yes, Your Honor.
All right, I'll reset this for sentencing September 5th,
At 10?
10 a.m.
Yes.
Thank you.
Thank you.
As much as you can between now and
September.
Okay, good.
Thank you.
Yes, sir.
State
Thank
of
you.
Ohio versus Joseph Green.
This is State of Ohio, Joseph Green, PRC 24-151, ABC, CRC 25-226. Matter set by Mr. Stratton's case. Okay.
What is happening today? Okay, cool. That starts
Monday.
Monday.
I already have it, but I'm starting every district.
Good report.
Thank you.
All right, Mr. Stratton.
Your Honor, we'll continue on until the state decides over.
I'm also going to pay $500 on my fines today.
Okay, I'll make a note.
And I did 1 day community service, and I know I got 4 days left. I'm about to start a new job Monday. When I figure out my schedule, I'm going to start doing the rest of my 4 days.
All right, get it knocked out. I'll set you back on September 5th, 2025 at 10 a.m. for something.
Thank you, Your Honor.
All right, thank you, Mr. Green.
Good job.
Keep doing what you're doing.
Thank you.
State of Ohio versus Holly Scarberry.
State of Ohio versus Tommy Scarberry, PRC 24-2473, ABC. Mr. Stratton's case got sentencing. All right, we had set this back, Mr. Scarberry, to see how you were doing, because you weren't doing so well last time. So let's see what your report says this time.
So you just got out detox? All right. Oh, okay? Okay.
All right. Well, it's a good thing you went to detox, Mr. Scarberry.
Thank you very much.
And so while I'm not particularly thrilled that you drank after our last conversation, I am very happy that you realized at that point that you needed a little more help than what was happening at that point. So I'll give you some more time since you went to detox on that. So I don't want to go out too terribly far though on this one. I believe you said you were available, hang on, sorry.
Any date except the 4th, 11th, and 18th.
I think the 15th was.
Okay. August 15th. August 15th.
That'll be a sentence right now. Mr. Scarberry, you're not out from under the gun yet. I'm happy that you went to the detox, and I'm hoping that certainly helps. Spending that time certainly has helped you, but you've got to do what they're telling you to do, and you've got to stay clean. Okay?
Yes, sir.
All right, I'll set you back for August 15th for sentencing.
All right, thank you, Your Honor.
Thank you.
State of Ohio versus Timothy Fuller.
All right, this is State of Ohio versus Timothy Fuller, CRD 17-1060. I've got, at least at one point, Attorney Mike Davenport was there to represent you, but I just said something different. All right, Mr. Fuller, since the last time we were here, what have you done?
I did community service for a day, and I paid some of my fine last time.
Are you working?
Yes,
Where are you working?
for myself.
All right, are you working tomorrow?
Yes.
Well, I'm gonna need to see.
I can go ahead, I can come tomorrow. I
Okay.
can go to work afterwards.
Okay, I'm gonna order you to come do community service tomorrow. You gotta start getting it done. This is a 2017 case. I mean, we're approaching a decade on it. I mean,
Yeah.
and I'm quite confident that you don't like coming to court and sitting back here all day waiting.
No.
So if you prioritize getting it done, you can have it and not have to deal with it anymore. So,
How much do I have left?
It's probably not updated.
I was gonna say, it was updated in May. In May, you had 54 hours left, but I'm assuming that some of that's been knocked off. And
Yeah.
$360 on your fine as of that point, but they'll update you if you want to check the probation as to the exact current figures that you owe.
Okay.
All right. I'll set you back September 5th for sentencing.
Thank you.
Thank you. September 5th.
Thank you.
State of Ohio versus Lindsey Jenkins.
So State of Ohio versus Lindsey Jenkins, here we put out 319, matter set of sentencing. Small Jenkins, were you able to get your license back?
No, not yet. I'm still paying on it.
Okay. Oh, what do you owe?
Huh?
What do you owe?
Like 1,000.
Is there any way I can just resolve this? Because I keep missing work.
You can. You've already entered the guilty pleas, and I've already found you guilty. So I'll go ahead and sentence on it. I'll give you a $150 fine where you pay the court costs.
Okay. Thank you.
Thank you. You'll need to see the clerk before you go.
Okay.
State of Ohio versus Raymond Wall.
This is State of Ohio versus Raymond P. Wall, here 23530 A, B, and C. Matter is set as a sentencing. All right. Mr. Wall, are you trying to get your license back?
Yeah, I'm trying.
All right, what do you to get your license back?
Reinstatement fee. For no insurance. Yeah, no insurance.
So you're not really, your license isn't being held now, you just gotta pay the reinstatement?
Yeah.
All right, I'll give you some more time to do that. Let's come back September 5th. That's sentencing, 10 a.m.
State of Ohio versus Donald Wilson.
The State of Ohio versus Donald Wilson Jr., PRC 07-2723 A, B, and C. This matter is set as a sentencing hearing. All All right, looks like you made a $50 payment on July 22nd. You finished all your community service. If you want to get this behind you, if they have any light duty things that you can do. But
We've already talked about that.
okay. Well, you made a payment, I'll just give you more time, so we'll come back to September 5th. And I'm going to set you back on the review docket now, so you'll get called at 9 a.m. on September 5th.
September 5th.
September 5th, 9 a.m.
Thank you.
All right, thank you.
Your Honor, we have 2 recalls that I haven't heard anything about.
Okay, Mr. All right, the State of Ohio versus Justin Lambert, CRB 2465. All right. We had Mr. Lambert out earlier. That's it, just an area from Tyler. We were trying to determine, I believe, whether the state needed to review on this matter. Again, this is State of Ohio versus Justin Lambert. You'll recall that I believe you guys were going to reach out to the alleged victim in this matter. Even in for domestic violence.
I don't know what happened to Jasmine.
She just went through.
Were you going to drive it? I don't even know if I told ask you to do this. I didn't. She was out doing another thing when I.
Let's recall this in a second. There's only 2 left, so. You may. State of Ohio versus William J. Cottle, PRC 251812 A and B. This is Mr. Morphy's case. We have had Mr. Cottle screened this morning, and then we had him assessed for possible treatment by OVP at this point.
Yeah, so he was accepted to our inpatient program. We just don't have a bed available today, so we're going to get him as soon as we get a bed available.
Okay. Any idea on how long?
It should definitely be over the weekend, I would assume.
All right. Mr. Milford?
Yes, Your Honor.
Well, let me start with the state, I guess, on this. On the matter of bond. I've got some concerns about letting Mr. Cottle, just walk out of here. There's no, he's not leaving immediately to treatment, given what's kind of transpired here today. But I'll defer to the state if there's any other information or anything that you'd like to state for the record, Mr. Gill.
Well, we shared the same concerns. It was pretty apparent that he's a man that's in need of the services that he's going to take advantage of. In between now and when he goes into OVP, we don't want him to relapse. We certainly don't want him to drive again during that period of time. I don't know whether the placing him in custody is the right thing to do at this point, but I don't know if that's what the court was thinking about doing. I certainly don't want something horrible to happen to him, and that would be someplace that would be safe. And if there was a GPS monitor available, which there probably isn't, he could be at home on a GPS monitor. That would be at least something.
Mr. Morford?
Judge, we've got no objection to being released on a GPS monitor.
Well, we don't have one. And it's afternoon on
Back
Friday.
at square
It's
one.
afternoon on Friday. So, I don't know that I have much choice, Mr. Cottle. So I think what I'm gonna do is I'm gonna have to remain you in the custody, but I'm gonna give you an OR bond, but the stipulation of the OR bond is that you're only to be released to treatment at OVP. Now, they'll come get you when they've got a bed available. That may be today, that may be tomorrow, that may be Sunday.
What about the meds?
So if you've got somebody with you here, then they can take the medication to the jail for you at that point, and then,
I have to be there to get it.
He's on methadone, so he goes to the clinic daily to get his methadone dose. That's the only medication he won't be able to get while he's there.
okay, well, you're just going to have to force, you're going to have to step that up, and you're going to be incarcerated until you go to OVP, and once you go to OVP, they're going to be able to take care of you from there. But, I mean, I don't think I can let you go with being.
I've never ran from anything, Your Honor, and I would show up.
Well, I'm not concerned about your running.
Oh, I'm not.
Yeah, I'm not concerned about your running, Mr. Cottle. I'm concerned that if I let you walk out of here today, that you take some fentanyl and then you die.
No.
And I know you say no, but and my concern is I don't trust you to let you walk out of here today. Now, if it wasn't fentanyl in your system.
Well, I mean, I would go to the VA today through the ER. And
Sure, and I understand you're saying that, but I've got no way to assure that you'll do so.
I give you my word, I can sign a bond or whatever. I mean, it's just right up the hill from my house.
Mr. Gill, what's your thoughts?
I don't want to see him in jail, but I also understand the court's concern. I wish there was a GPS monitor. I wish that there was a bed available. If it weren't for the fact that he has West Virginia insurance,
That certainly complicates the scenario.
yeah, I was thinking a detox, somewhere. Are you VA?
Yeah.
Wonder if the VA would have some sort of emergency.
I'm sure they do. My concern is we don't have any way to assure that he actually goes. That's my only concern at this point, especially with the comments that you made on the record earlier. When I indicated that I had concerns that you were on something now. And that's my concern.
Should I tell him that I dosed this morning? Should I tell him that I dosed this morning? Should I tell him that I dosed this morning? And that's the reason why.
Well, I think he probably knows that. It's appearing in your screen.
Well, I mean, okay. The reason why I was so a little bit out of it is because I dosed right before I came here, and
I know, that's one of my really big concerns. I mean, you did it right before you came to court.
I had to,
But that's my concern. If you're saying you had to dose.
Well, I didn't know how long I'd be here, and they closed at 11.
Oh, you're talking the methadone?
Yeah.
Okay. Do you have somebody here with you today?
Yes, my mother.
Ma'am, could you step up here? Right there is fine. Can you hear me okay?
Can I what?
Can you hear me okay?
Yes,
All right, so have you heard what we've been discussing?
kind of,
All right, well, you're his mother, is my understanding.
yeah.
So he has tested positive today for a drug that can kill him. Fentanyl kills people every day in this community. And I have some concerns about just letting him walk out of here.
I understand.
Because I'm sure that you don't want anything bad to happen to him, and neither do I. There's been a proposal, because he's a veteran, about him going to the emergency room at the VA. Normally, I wouldn't consider this, but what are your thoughts on that?
Do you want him to be housed at the VA?
That would be up to them ultimately, but I would imagine if they knew what he tested for,
Right.
that's probably what's going to occur. But I wanted to get your thoughts. Are you driving him today?
Yes,
Okay.
Would you take him to the VA?
yes. I go there a lot.
Okay.
Okay. Because here was the problem we had, where he's got West Virginia insurance, there was only one provider that could take him. They don't have a bed available immediately for him. And then I don't trust him to walk out of here on his own and then later in the weekend get a call and say, oh, I've got to go, and not something bad happened to him. And so if you will take him directly to the VA for treatment when you leave here, I would be willing to allow him to do that, so long as you're driving and you're telling me that you're going to take him. Okay? All right. So here's what I'll do, Mr. Cottle. I'm going to set bond at $2,500 OR. And I'm going to note that you're going to go to treatment at the VA immediately.
Yes.
And if you were to leave and not do the treatment, that's going to be a violation of your bond. Do you understand that?
Yes.
And then at that point, I don't have much choice. And, I appreciate your service, and with your mother being here and agreeing to take you, I feel at least comfortable enough to let you go to the VA. Otherwise, I think my hands would be tied, and you'd have to lay it out in jail over the weekend.
And he would agree to follow all recommendations by the VA girl.
Okay. All right, this was an OBI, when do we want to come back?
22nd?
Okay.
That's good with you?
That's good with you, Mr. Gill?
We're okay with that.
All right. We'll set this matter for first pretrial, August 22nd, 10 a.m. Mr. Cottle, you're going to need to bring with you when you come proof that you are in the treatment and that you're compliant with the treatment. Okay. And I know Ms. Rayburn typically updates the court pretty regularly with those things, but you'll need to sign paperwork allowing her to do so.
Your Honor, is he going to have to go to the jail and be fingerprinted?
It does need to be fingerprinted before you come back. So you're going to need to go to Lawrence County Jail, get a fingerprint done down there just before you come back.
Don't believe I'll bring you a copy of this after we change.
All right.
Thank you, Your Honor.
So,
Thank you, Mr. Mill.
You're welcome.
All right, State of Ohio versus Justin Lambert, CRB 24652. I don't know if you had an opportunity to.
We had to leave a voicemail here.
Okay. All right, so we enter a not guilty plea on behalf of Mr. Lambert. Mr. Lambert, are you working currently?
No, I'm in OVP.
Okay. All right, I'm going to, are you on OVP for a case out here? Or-
No, I'm there on my own.
Okay. All right, I will, if you're not working, I'll appoint attorney, who do we have left here?
Morford, for sure.
All right. I'll appoint attorney Butch Morford to represent you. He's going to be coming in the courtroom here in just a second. I'm going to set bond at $1,000 OR. Mr. Gill, any requests on protection order?
Yes, Your Honor.
All right. All right, Mr. Lambert, at least for now, Mr. Morford, this is Justin Lambert, it's an M4 domestic violence. We have called it several times to see if there was even, it's an older case from 2024. And so we had set the matter, we recalled it to see if it was something that was even going to be pursued at this point given its age. However, we haven't been able to get in contact with the alleged victim. So we're going to go ahead and set a temporary protection order out of an abundance of caution for Brian Scott Lambert. So, Mr. Lambert, you're not allowed to be able to have contact with Brian Scott Lambert. And then if he decides that in the meantime that he doesn't want that protection order, he can reach out to the prosecutor's office and it can be withdrawn. Additionally, I'm sure they're going to be reaching out to him to see if this is a matter that he wants to be pursued.
He lives in Pennsylvania, so.
So that's not going to be a problem?
Yeah.
Okay. All right, I'm going to set you back. I don't see any need to come back quickly on this, given if you're indicating he's in Pennsylvania. So I'm going to set it back September and get fingerprint done.
Okay.
So there'll be a fingerprint order, so you'll have that, you need to get that done before you come back.
Okay.
Don't leave, and I'll meet you in the lobby and give you a paper to take.
Okay.
All right, this matter will be set back September 5th, 2025, 10 a.m. for a pre-trial.
Thank you, Your Honor.
Thank you, Mr. Morgan. That's it. All right, court's adjourned.
What date are we coming back on that last one?
September 5th.
5th?